A bomb that was planted more than half a century ago has finally gone off, and the state of Arizona is the one standing closest to the blast. For decades, a deal struck in the 1960s sat quietly in the foundations of the Colorado River water system, a bargain that seemed reasonable at the time, a compromise that unlocked one of the most important water projects in the history of the American West. But that deal contained within it a hidden charge, a clause that would only detonate under the right conditions, and now, as the river has fallen into crisis and the water has grown desperately scarce, those conditions have arrived. The charge has gone off at last, and of all the states that share the river, Arizona is the one bearing the full brunt of the explosion. The state is being forced to give up more of its water than anyone else, cut more deeply than its neighbors, made to absorb the pain that others are spared, and now Arizona is preparing to do what once would have been almost unthinkable for a state so dependent on federal cooperation. It is getting ready to sue the federal government over water. To understand how it came to this, you have to understand the deal, and to understand the deal, you have to understand the peculiar and painful position that Arizona has always occupied in the sharing of the Colorado River. The river is divided among many states, each entitled to a share of its water, and for a long time, the great question was how to get that water to the places that needed it. For Arizona, this was a particular challenge, because much of the state's population and its most important growth lay far from the river, in a region that could not easily be reached by the water without an enormous and expensive system of canals and pumps to carry it across the desert. Arizona desperately needed a great project to deliver the river's water to its cities and farms. A massive undertaking that only the federal government had the resources to build. And here is where the fateful bargain was struck. In order to secure federal support for the great project that would carry the river's water across the state, Arizona had to make a concession, a compromise that would prove momentous, to win the agreement of the other interests involved, particularly to overcome the objections of a powerful neighboring state that also drew on the river. Arizona accepted a subordinate position in the order of priority for the water that its new project would deliver. In essence, Arizona agreed that in times of shortage, the water flowing through its great new project would be among the first to be cut, that its claim would rank below the claims of others, that it would bear the reductions before its neighbors did. This was the price of getting the project built, the concession that unlocked the federal support, the deal that Arizona accepted in the 1960s in order to secure its water future. At the time, this concession may have seemed like a reasonable price to pay, even a clever bargain, because the risk it created appeared remote. The river seemed abundant. The shortages that would trigger the deep cuts seemed unlikely, a distant hypothetical that might never come to pass. Arizona got its great project. The water flowed across the desert, and the state grew and prospered on the strength of it, its cities swelling, its farms flourishing, its economy booming. For decades, the subordinate position in the priority order was an abstraction, a clause that sat unused in the foundations of the system, because there was enough water to go around, and the shortages that would activate it never materialized. The bomb was planted, but the conditions to set it off had not yet arrived, and so it lay dormant, its danger unrealized, while the state built its future on the water the deal had secured. But the conditions have now arrived, and the bomb has detonated. Over the years, the Colorado River has fallen into a deepening crisis, its flows diminished by a long and severe drought and by the warming of the climate, its great reservoirs drained toward dangerous lows by the persistent gap between what the river provides and what the region takes. As the crisis has deepened, the shortages that once seemed remote have become reality, and the system has been forced to impose cuts, to reduce the water delivered to the users who depend on it. And because of the deal struck in the 1960s, because of the subordinate position Arizona accepted in exchange for its great project, those cuts have fallen first and hardest on Arizona. The state that made the concession decades ago is now paying the price, bearing reductions far deeper than those imposed on its neighbors, watching its water supply slashed, while others are protected by the priority they hold over Arizona's claim. This is the detonation of the 1960s deal, the moment when the hidden charge finally goes off. And it has placed Arizona in an extraordinarily difficult and, in the view of many within the state, deeply unfair position. Arizona is being asked to sacrifice more than its share of the pain, to absorb a disproportionate burden of the cuts. All because of a bargain made generations ago under very different circumstances. A bargain whose consequences are only now being fully felt. From Arizona's perspective, the situation has become intolerable. An arrangement in which the state bears the heaviest losses while others are shielded, in which the concession made to secure the project has become a trap that threatens the state's water security and its future. And it is this sense of intolerable unfairness, this feeling of being made to bear more than its fair share, that has pushed Arizona toward the drastic step of suing the federal government. The prospect of a lawsuit represents a dramatic escalation in the long struggle over the river, a sign of just how badly the crisis has strained the arrangements that have governed the water for decades. For a long time, the sharing of the Colorado has been managed through negotiation and agreement, through a framework of compacts and deals and rules that the states have worked out among themselves, however contentiously. To turn to the courts, to sue the federal government, is to abandon that approach, to declare that the disputes can no longer be resolved through negotiation, that the conflict has become too fundamental to settle through the usual means. It is a step that carries enormous risks and uncertainties, one that could tie the fate of the river up in litigation for years and produce outcomes that no one can fully predict. That Arizona is prepared to take such a step is a measure of how desperate and how aggrieved the state has become. What exactly would Arizona be suing over? At the heart of the dispute is the question of how the burden of the shortage should be shared, and whether the arrangement that forces Arizona to bear the deepest cuts is fair or lawful under the full body of law and agreement that governs the river. Arizona's position, in essence, is that the way the cuts are being allocated places an unjust and unsustainable burden on the state, and that the federal government, which operates the system and imposes the reductions, bears responsibility for an outcome that Arizona considers unfair. The state may argue that the circumstances have changed so dramatically since the 1960s deal was struck that its terms should not be applied so rigidly now, or that other principles of law and equity should temper the harsh consequences of the old bargain. The precise legal arguments are complex, but the underlying grievance is simple. Arizona feels it is being made to suffer disproportionately, and it is turning to the courts to seek relief. The federal government's position is different, rooted in its responsibility to operate the system according to the established law and agreements, including the very deal that Arizona now finds so painful. From the federal perspective, the priority order that places Arizona's project in a subordinate position is part of the legal framework that governs the river, a framework that was agreed to by the parties, including Arizona itself, and that must be applied as the shortages require. The federal government operates the great dams and reservoirs, and it is bound to allocate the water according to the rules, even when those rules produce harsh outcomes for particular states. To simply set aside the priority order that Arizona accepted, to spare Arizona the cuts it agreed to bear, would be to undermine the entire legal foundation of the system and to disadvantage the other states that hold the senior claims. The federal government thus finds itself defending an arrangement that Arizona is attacking, caught between the competing claims of the states and bound by the law it is charged with enforcing. This is the essence of the conflict, a collision between Arizona's sense of intolerable unfairness and the federal government's obligation to uphold the established rules, a collision made possible by the 1960s deal and triggered by the crisis of the river. And it is a conflict with enormous stakes, because the outcome will help determine how the pain of the shortage is distributed. Which state bears how much of the burden, whose water is protected, and whose is cut. For Arizona, the stakes could hardly be higher, because the state's water security, the foundation of its economy and its future, is on the line. The deep cuts that the 1960s deal imposes threaten the water that Arizona's cities and farms depend upon, and the lawsuit is in essence a fight for the state's water future, a desperate effort to escape the consequences of a bargain that is turned against it. To understand why this matters so much to the people of Arizona, it helps to see what the deep cuts actually mean on the ground. The water delivered by the Great Project is not an abstraction, but the lifeblood of a large part of the state. Flowing to the cities that have grown enormous in the desert, and to the farms that have turned arid land into productive fields. When the cuts fall, and because of the 1960s deal they fall first and hardest here, it is this water that is reduced, and the reductions ripple through the economy and the daily life of the region. The farms that depend on the project water are among the first to feel the loss, forced to leave fields unplanted, to abandon crops, to watch the agricultural economy that the water made possible begin to wither. The rural communities built around that farming face a threat to their very survival, as the water that sustained them is cut away. And while the cities, with their more senior claims to certain supplies, may be more insulated for now, the deepening cuts cast a shadow over the entire state's future, over its capacity to keep growing, over the security that its residents have long taken for granted. This is why the sense of unfairness runs so deep, because the people of Arizona feel they are being asked to sacrifice their livelihoods and their future to honor a bargain struck before many of them were born. A bargain whose harshest consequences they never chose and can barely understand. A farmer watching his fields go dry, a community watching its economic foundation erode. A state watching its water security slip away, all because of a concession made decades ago in a deal to build a canal, is bound to feel a burning sense of injustice. That feeling, multiplied across the many people affected, is the emotional fuel behind Arizona's move toward the courts. The sense that the state and its people are being treated unfairly, made to bear a burden that should be shared more evenly. It is not merely a legal dispute over the technicalities of water rights, but a fight over the fairness of who suffers and who is spared in a time of scarcity, and that is a fight that stirs deep feelings and hardens positions on every side. It is worth dwelling on the tragic irony at the heart of this situation, because it captures something important about how these crises unfold. The very deal that once secured Arizona's water future is now threatening it. The bargain that unlocked the great project, that brought the river's water across the desert and enabled the state to grow, contained within it the seeds of the present crisis. The subordinate position that would eventually force Arizona to bear the deepest cuts. What seemed like a shrewd and reasonable compromise in the 1960s, a price worth paying for the project, has become, in the changed circumstances of the present, a source of profound vulnerability. The deal that gave Arizona its water is now the deal that takes it away. And this irony is the essence of the detonation, the way a bargain made in one era, under one set of assumptions, can become a disaster in another. There is a broader lesson here about the danger of building arrangements on assumptions that may not hold. The 1960s deal was made on the assumption that the river would generally provide enough, that the shortages triggering the deep cuts would be rare and manageable, that the subordinate position Arizona accepted would remain a distant abstraction. Those assumptions have proven false, undone by a drought and a warming climate that have reduced the river far beyond what was anticipated, and the arrangement built on those assumptions has produced consequences its makers never intended or foresaw. This is a recurring pattern in the story of the Colorado, the way that deals and rules and allocations made in a wetter. More abundant era have become sources of crisis and conflict in a drier, more scarce one, the way that the foundations laid in the past have cracked under the pressure of a changed reality. Arizona's plight is a particularly acute example of this pattern, but it is not unique. What makes the prospect of a lawsuit so significant is that it threatens to unravel the cooperative approach that has, for all its difficulties, kept the sharing of the river from descending into open conflict. For decades, the states have managed to work out their differences through negotiation, however contentious, preserving a framework of agreement that has allowed the water to be shared without resort to the courts or to unilateral action. A lawsuit by Arizona against the federal government would represent a breakdown of that cooperative approach, a turn toward confrontation and litigation that could poison the relationships among the states and make future agreements harder to reach. And it could set a precedent, encouraging other states to pursue their own grievances through the courts, fragmenting the management of the river into a series of legal battles. The risk is that the turn to litigation could make an already difficult situation even worse, replacing the possibility of negotiated compromise with the uncertainty and hostility of a legal war. Yet, from Arizona's perspective, the turn to the courts may feel like the only option remaining. A last resort forced upon the state by the intolerable unfairness of its position and the failure of negotiation to provide relief. If Arizona believes that it is being made to bear an unjust share of the burden, and if it has been unable to secure a better outcome through negotiation, then the courts may seem like the only avenue left, the only place where the state might find the relief it seeks. From this perspective, the lawsuit is not an act of aggression, but an act of desperation, a state pushed to the edge by a crisis and a deal that have turned against it, reaching for the only tool that remains. Whether the lawsuit is wise, whether it will help or harm, whether it will produce relief or only deepen the conflict, is uncertain, but the impulse behind it is understandable, the response of a state that feels it has run out of other options. The situation also raises profound questions about fairness and about how the burdens of a shared crisis should be distributed. Is it fair for Arizona to bear the deepest cuts because of a deal made generations ago, under circumstances that no longer apply? Or is it fair for the other states to be held to the priority they were promised, the senior claims they hold under the established rules? There is no easy answer, because both positions have their logic. Arizona can argue that the changed circumstances make the old deal unjust, that no one anticipated the depth of the crisis when the bargain was struck, that it is unreasonable to force one state to bear so much of the pain. The other states can argue that a deal is a deal, that Arizona accepted the subordinate position knowingly in exchange for its project, that the rules must be honored or the whole system collapses. This tension between the claims of the past and the demands of the present, between the sanctity of agreements and the imperatives of fairness in a crisis, is at the very heart of the dispute. Whatever the merits of the competing arguments, the prospect of Arizona suing the federal government is a sign of how severely the crisis of the Colorado River has strained the arrangements that govern it, how the pressure of the shortage is causing the old framework to crack and buckle. The deal of the 1960s, the priority order it established, the whole intricate structure of law and agreement built up over decades, was designed for a world of relative abundance, a world in which the river generally provided enough and the deepest conflicts could be avoided. That world is gone, replaced by one of scarcity and hard choices, and the old framework is proving unequal to the new reality, producing outcomes that some of the parties find intolerable and driving them toward confrontation. The lawsuit is a symptom of this larger breakdown, a sign that the system of sharing the river is under a strain it may not be able to withstand. Looking ahead, the resolution of this conflict, whether through the courts or through a renewed effort at negotiation, will have profound implications for the future of the river and the region. If Arizona proceeds with its lawsuit and the dispute is fought out in the courts, the outcome could reshape the allocation of the river's water, determining how the burden of the shortage is shared for years to come, and setting precedents that could affect the entire system. If, instead, the threat of litigation prompts a renewed effort to reach a negotiated solution, one that addresses Arizona's grievances while preserving the cooperation among the states, then the crisis might be resolved more constructively, though only if the parties can find a way to share the pain that all can accept. The path the region takes, toward the courtroom or back to the negotiating table, will shape not only the outcome of this particular dispute, but the way the entire system of sharing the river evolves in an era of growing scarcity. In the end, the story of Arizona's move to sue the federal government is a story about the collision of the past and the present, about the way a deal made in one era, under one set of assumptions, can detonate in another, producing consequences its makers never imagined. It is a story about the deep unfairness that can arise when the burdens of a shared crisis fall unevenly, about the desperation of a state pushed to the edge, and about the fragility of the arrangements that have, for so long, kept the sharing of the river from collapsing into open conflict. The 1960s deal has finally detonated. Arizona is bearing the brunt, and the state is preparing to fight in the only way it feels it can. Where that fight leads, whether to a courtroom battle or a negotiated resolution, whether to relief for Arizona or to a deepening of the conflict, remains to be seen. But the detonation of that old bargain is a warning of what lies ahead as the crisis of the Colorado deepens, a sign that the deals and rules of a wetter past are cracking under the weight of a drier present, and that the struggle over the river's dwindling water is entering a new and more dangerous phase, one in which the old cooperation